Good afternoon, everyone. Hi, my name is Mariah. I work at Support for Families. I'm here to welcome you guys to this workshop and give a big thanks to Alexis Lynch here today to present for us. I just wanted to go over some logistics. So I want to make sure everyone has registered at the front. If you haven't, at the end of the presentation, fill that out. Everyone should have a evaluation in front of them. If you could complete that at the end of the presentation. In order to keep our services free, our funders do require us to give them some questions. Please fill that out. And we ask that all of your cell phones are on silent or on vibrate. And then we do have interpretation. So if you did sign up for interpretation, you should have received an email with some instructions. But our interpreters here. I don't know if you'd like to say it.
Si alguien necesita servicios de interpretación en español, hay un número que pueden llamar.
I'm blocking it.
Pueden llamar el número y marcar el PIN. Alguien cree que lo necesita para hacerlo. Pueden marcar ahí y el número del PIN de abajo con el asterisco y él me puede escuchar a mí.
Yes. The interpretation, the phone number is right there. And then lastly, if you guys would like to make a donation, there is a table downstairs. Go and check that out if you'd like. And with that, I think we can get started.
Thanks, Mariah. Yeah. All right. First of all, to my interpreter, let me know because I tend to speak quickly. So just feel free to tell me to slow down. Okay. I'm Alexis. Hi. I'm so excited to be back here. I've done this conference many times, and it's great that it's going again. I am here to talk about conservatorship today. The first thing I always like to say, I'm an attorney. This is what I do every day. Like 95% of my work is conservatorships. You do not need to have an attorney to do this process. I always say that from the get-go. My job here today is to give you information about conservatorship and how you set one up. So if you are going to take this on yourselves, which many families do, you will have a lot of resources coming out of here, okay? Or you can hire an attorney who will help you with the process. So I'm an attorney. I'm located in Marin. I have done conservatorships in 12 or 13 counties at this point. So it's a statewide system. I will be speaking to the statewide system because most of it is universal, but there's little nuances between county courts. I know a lot of people here today are San Francisco County. Are there other counties represented here today besides San Francisco? Yes. Alameda, great. Anyone else? Yes. San Mateo, okay. Alameda, San Mateo, San Francisco. Anyone I'm missing? Okay, I'm gonna point out small differences along the way then when we get to those parts. Okay, I'm gonna go through all the materials and then I'm gonna stick around for questions. And I'm happy to stay past the hour mark or whatever it is if you guys have questions, okay? I'm pretty good at knowing what questions are coming, so hopefully I'll answer a lot of your questions even before you can ask them. Okay, let's start at ground zero. What is a conservatorship? So conservatorship became a very hot topic thanks to Britney Spears over the last couple years. So you've probably heard about it in the news a lot. The idea behind conservatorship is you have an adult, and that is someone who is 18 or over in the state of California. Okay, they have to be 18 or over, that cannot provide for their own needs for things like food, clothing, and shelter. Oh, stop. These slides are available in a handout, which I did provide to Support for Families. I don't know if they were able to get them to you. If you want them, at the end of all these slides will be my email address, and you can email me and I will send them to you. So if you're scribbling furiously, you can chill out a bit, and I'm happy to provide all of this, okay? All right, so you have an adult who's 18 or over, and that person needs assistance providing for their own needs. Food, clothing, shelter. They can't manage their own finances. They can't make good decisions for their own medical care. All right. If you have an individual like that who's an adult, then the court can appoint someone else to be in charge of making those decisions for that person. Okay, that's the idea behind conservatorship. There are a couple terms I'm going to be using a lot today. Conservator is the person who's placed in charge of helping. Okay, conservatee is the individual that needs assistance. So I'm going to probably use those terms quite a bit. Within conservatorship, there are actually three real main types. The two main types, though, are general and limited. All right, today we're talking about limited conservatorship because that means an individual who has a developmental disability. In California, they have carved out specific conservatorship for individuals with developmental disabilities, a limited conservatorship. A general conservatorship would be more for like an elderly person who's lost their faculties, such as they have dementia. Okay, so that's general conservatorship. We're talking limited. Now, the reason it's called a limited conservatorship is because as opposed to general conservatorship, they just grant a general conservatorship and they say, okay, now you get to just make all decisions. In limited, they really want to protect the rights of individuals with disabilities. So they have carved out in the law, and we'll go through these in a little bit, specific decision-making authorities you can request to have. And then they're going to decide, the court's going to decide which of those decisions are appropriate for this case. Okay, so that's why it's limited. They're going to limit the decision-making powers that they grant to you based on the needs of the individual. Okay, let's see. Quickly, because I do get a lot of questions about this. There is an LPS conservatorship, a different category of conservatorship, specific to individuals with severe mental health issues. That is very separate. Okay, it's a very hard to get an LPS conservatorship. It requires an individual to have been in and out of psychiatric involuntary holds. It's supposed to be initiated by the county's public guardian. That's a whole different animal. But I do get questions about this because there are many individuals who obviously have severe mental health issues also that need that type of assistance. We are talking only about limited conservatorship today, which does not give you the right to force psychiatric treatment. Okay? All right, so within your limited conservatorship, you have a conservatorship of the person and a conservatorship of the estate. Conservatorship of the person, you get to make decisions about their personal care. Where are they going to live? What type of school will they attend? What type of medical treatment will they receive? Okay, those types of personal care decisions, as opposed to a conservatorship of the estate where you're managing their finances. Now, you don't need to have both. You can have just a conservatorship of the person. That is 95% of the cases I handle because the individual being conserved doesn't have income or assets, or they might have income, but it's public benefits, such as SSI. You don't need a conservatorship to manage their SSI, okay? What you can do to manage their SSI is on the bottom of this slide. It says you can be a representative payee, and there's a website listed right there. Surprisingly, the Social Security Administration has actually really helpful information. They actually have a fairly good website for navigating. So you can read about being a representative payee online. And when you go through the SSI application process, you can ask to be the representative payee. Okay, so today we're really only going to focus on conservatorship of the person because it's so rare that an estate is needed. Okay. So this is always the big question. Do you need a conservatorship, and what are the alternatives if you don't want to go the conservatorship route? This is not a black or white, answer. It's very case dependent, obviously. But I'm going to give you, going back, let's not go to alternatives yet. I'm going to give you just some extreme. So don't take these to be like, I'm not trying to create hysteria. I'm just going to give you some extreme examples of clients I've served that needed conservatorship. Okay. An example, a client whose 30-year-old daughter who had the cognitive capacity of like a preschooler needed cataract surgery, just a basic cataract surgery so she could see. The hospital said, we can't perform. She doesn't have the capacity to consent to the surgery. You can't consent because she's over 18, so we can't do the surgery. They were just stuck. So they had to come to me, get a conservatorship, and then she could have her surgery. Okay, so medical treatment is a common one I see. Also, just not even that extreme, just wanting to still be able to make those decisions, be in the room with the doctor and your child and discuss, are they going to get the COVID vaccine? Do they need to have a surgery for blah, 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 whatever it is, right? Still having that authority once your child turns 18. Other example, a client whose daughter was living in an apartment with the supported living services through an agency, and wasn't getting great care. I mean, her glasses were broken for 3 weeks. She couldn't see, they had like a whole list of things that she just wasn't getting the support from the supported living services that she needed. So the parents said, well, we want to switch to a different vendor through the regional center. And the regional center said, well, we can't because she won't agree to it. She kept saying, no, I don't want anything to change. She was very adverse to change. And her parents would go visit her over and over and find all these things that were not being done that she needed done. So the GGRC said, you have to get a conservatorship so that we can work this out with you. Okay, things like that come up. IEP meetings. Some IEP, they will let you sit in on the meeting if your child has given permission, but that doesn't grant you the right to make decisions. Okay, so there can be extreme examples. Now, all that being said, plenty of my clients don't come to me for years because they go years without ever hitting any roadblock. All right, and then something just eventually happens and they need to have some authority to navigate something. Other clients of mine come to me before the kid turns 18 because they just want the peace of mind. They don't want to have to worry that roadblock will come someday and they won't be ready for it. So that's something to know. It's not like this has to be done when your child turns 18. What are alternatives? So, the basic alternatives are some sort of legal document that your child can sign that places you in a position of authority. Okay, so for instance, an advanced healthcare directive. Many of you probably have your own advanced healthcare directive you've signed that says, if you're in a vegetative state, so-and-so gets to make decisions for you. Okay, well, you can have an advanced healthcare directive that says, I am deciding right now that I want this person to make decisions for me now. Okay, so that is an option. You can go to your medical provider or your child's medical provider and ask them for that. That gives you authority for medical decisions. Another option, power of attorney. You probably hear that term a lot. That's really in regards to finances. Some of you might have a power of attorney of your own that says when you need help, so-and-so can step in and manage your finances for you. And a release of information. That's a very basic one that the regional center, a school, whatever agency is assisting you, they can have your child sign something that says, I allow you to release my confidential records to my mom. Okay, now that's not giving you decision-making authority, but it's granting you access to information you'd want to have that is otherwise sealed. Okay, so those are some great options. Now, this last one, supported decision-making, this is a big one. This has not been put into law in California yet. It has in some other states, but it's coming, okay? I'm not gonna go into a ton of detail about it since it's not law in California, so I can't even outline for you exactly what that would mean, but it's a good option for individuals who are higher functioning, okay? What it does is basically you come up with a formal, legal, written document where the child decides, I want these people, and they would name the people, to be part of my decision-making team. Now, it's not giving you decision-making power, but it's letting you have a seat at the table and guide them to make good decisions. Okay? That's the idea behind it. So again, California, not codified by law yet, but it will be coming at some point. It's already been through, they already have it all written up. It just hasn't been, and it's been approved. It's gone through, but it just hasn't been signed into actual law yet. So who knows? I don't know how long that will take. We all know how that goes. So this is something I highly recommend looking at. Like the ACLU has a page dedicated to it. The supporteddecisionmaking.org has information. So that's just something I really want to stress for those of you that don't, are resistant to the conservatorship route, and maybe it's not necessary for your child, this is a really good thing to consider. Now, even though I'm saying it's not codified in law yet, that's not to say that people in California aren't using it yet. There are people out there that have written up agreements and present them to GGRC or whoever it is, and have some success. So, all right. So back to conservatorship now. Let's talk about what is your standard of proof that you need to show in order to even get a conservatorship. It's such a broad standard. It's, can the individual provide for their own needs for food, clothing, shelter, and physical health without assistance, basically. And I had a client once say to me, well, my typical teen can't do this either. And I was like, right, it's a pretty broad standard. So now that being said, it is a broad standard, but what we'll go through is we'll talk about how the court looks at your case and determines if a conservatorship is necessary. Okay, we'll talk about that. A conservatorship of the estate is going to be they can't manage their own finances, or they're subject to undue influence or fraud. Example, I had a client whose brother was hanging out with a shady character in the neighborhood, and that guy convinced him to go into a bank, take out a $10,000 line of credit, and give him the money. Okay, that's someone who didn't have finances to manage, so didn't need a conservatorship at the estate, but was subject to undue influence and fraud, and then they had to get a conservatorship of the estate to clean up the mess. So that's another example. So now this is what I was talking about. California law has made 7 decision-making powers you can have through a conservatorship, okay? You get to choose when you go to court and ask. You get to choose which ones you're going to request. You don't have to request all 7, or you can. So this is the list: deciding where they live, having access to their confidential information, entering into contracts for them, consenting to medical treatment, making decisions concerning their education. And then these 2 bottom ones are controversial: controlling their social and sexual relationships, and consenting or withholding consent to marriage. Okay, and those 2 I'll revisit again in a little bit. But this is what the law allows you to request, to have decision-making authority about. All right, important. Oh, that's so funny. Okay, important. Conservatorship, the idea behind it, and especially now after Brittany, who got royally screwed, honestly. Conservatorship is not you stepping in and saying, you're an adult now, but I'm controlling it all. I'm making all your decisions, and you don't know what is best for you. Okay, that is not the idea behind conservatorship. Conservatorship, the idea is you may run into roadblocks in trying to access the best services for your child, or protecting them from something bad that's happening to them, or whatever it is. And you then need to have the authority to step in and help. That's the idea. You are supposed to be promoting your kids' maximum independence by enrolling them in programming, engaging them in the community, whatever it is. That is the idea behind it, and helping them become the most independent version of themselves that they can. All right, that's really important, and that is what courts want to see. So who acts as conservator? Parents is, obviously the most common, okay? Sometimes siblings, parents and a sibling, or siblings once parents are no longer able to do it. You can have co-conservators, like parents will be co-conservators together, or a parent and one of the siblings will be co-conservators together. Co-conservators, that means you share equal decision-making authority. You have to agree and make the same decision. Okay, that's important to know. You can't have someone be like the primary decision maker and then this other person is like the secondary. Nope, every co-conservator shares equal authority by law. And then there are professionals who do this as well, and for a fee, obviously, if there are no family or friends or anyone who can do it. A lot of times people ask me at that point, what happens if you can't be conservator anymore? And I will talk about that. So that's later, okay? All right, we're going to talk about the process now. So this is just showing you where we're going to be going. There's a process to set one up through the court, obviously, and we're going to start from the beginning and work our way through. And this is where I'll be highlighting small differences between Alameda, San Mateo, and San Francisco. So the very first place to start, I always say, is something called the capacity declaration. This is a big part of your case, especially if, well, not especially, specifically if you want to have the authority to make medical decisions, okay? This is something that a doctor needs to fill out, one of your children's treating doctors needs to fill out to determine if the individual lacks capacity to give informed consent to medical treatment. All right, now I always tell people, make sure your doctor is going to fill this out for you and make sure they're going to fill it out in a way that supports your case, because we need to know that we have this before we start, getting into the nitty-gritty here. So it needs to be a California licensed physician or psychologist, California licensed. And this form, which you can find online, all the forms you can find online, which I'm going to get to in a moment, this form has basically a scale. It's a hard word to get, apparently, a scale of impairment of cognitive functioning. So it'll say like alertness or logical reasoning or abstract concepts or, short-term memory, long-term memory, all these mental functions, I think the form calls them, where the doctor indicates what level of impairment the individual has. No impairment, moderate impairment, severe impairment, or so impaired so as not to be assessed, basically. So they need to mark that the individual has impairments, obviously. And then at the end of the form, they need to indicate that the individual, they check a box that says they lack capacity. All right, so that is a very important first step that I always suggest you start there and see if your doctor is going to complete this paperwork for you. Okay, now you've spoken to your doctor, they're happy to fill it out. That's all good and dandy. Now what? Now let's talk about actually getting this case underway. So you're going to have to file a petition. Where do you do this? You do it in the county where your child lives. If for any reason they live in a different county from you, you're doing it in their county, okay? And you're doing it in the probate department. Probate handles wills and trusts when people die and that stuff, and they handle conservatorships. When do you do this? That's a big question I always get. So I mentioned this is for an adult, someone who's 18 or over. So you can't put a conservatorship into place until they're 18, but you can do it in advance. So the hearing will be right around their 18th birthday, and then it'll be in place for their 18th birthday. That timeline being said, when should you start? If you want it in place for their 18th birthday, I always say 6 months. Alameda, you might want to start sooner. So San Francisco, Alameda, and San Mateo, actually all are probably roughly the same. So generally you're looking at, if you give your paperwork to the court, they're going to give you a hearing 4 to 5 months later, okay, in any of those counties. So you also want to take into account getting your paperwork done. So, you might want to start the process, let's say like 7 months in advance or so, okay? Or you can just do it anytime after they've turned 18. They can be sick. I just did one for a 60-year-old gentleman. So it just, that 18 mark isn't, like a deadline, although for some people it is because they have something very pressing happening. And then the cost. So there is a cost just to file a case, but most people qualify for a fee waiver, all right? And that fee waiver, that fee waiver applies, it's not based on you, it's based on the individual being conserved. So if your child doesn't have income or assets, then they are qualified for a fee waiver. If they receive SSI, Medi-Cal, or IHSS, that's an automatic fee waiver. In the form, and this is the form right here, FW001GC, in that form, it actually asks you, and you can check boxes that they receive any of those services. And then if they don't receive any of those, but they don't have income or assets, that's another way to have, that's another box you check. All right. So you could have all the fees waived potentially and not pay to have this conservatorship set up. All right. These are the forms that are going to be needed at any county. Okay, this is California-wide forms. These are called judicial council forms. They are available online. You can, the easiest way to find any form is just to Google it and it comes right up, and then click on it, and they're fillable forms online. Okay, so this is, I'm not going to go into this, we could go so in the weeds and I'm not going to, but we will be talking about some of these as I move forward. This is just a good laundry list of where to start. Okay. Oh, and then look, every court, let me think, the 3 courts that are here, every court here also has their own forms, so on their own website. Okay, and that's something that you can easily find out about and ask when you're filing a case. Okay, so let's say you have done all your paperwork, you have filed your case, and you have a hearing date set. What happens? So the first thing is you need to notify certain people that this hearing is going to take place. That includes the individuals, some of the individuals' relatives. Both parents need to be notified, unless you're the people, both parents are actually doing it. You don't have to notify yourself. But both parents need to be notified. Siblings need to be notified, no matter how old. Under 12, it's care of the parent. And then grandparents need to be notified. And the way you notify them is by mail. There's a specific form, notice of hearing, that you send with a copy of the petition, and you mail it to these people. Whether they open it, whether they read it, whether they engage in any way, that doesn't matter. You just have to sign a sworn statement that you have mailed it to these people, okay? You also need to notify the regional center. And I'll talk about the regional center's involvement in a moment. And then you need to notify the attorney for the individual being conserved. They, by law, get their own attorney. In San Francisco and San Mateo counties, that attorney will be someone like me. I actually used to sit on San Francisco's panel. It's attorneys like me that do this all the time for people like you, but volunteer our time on the other side to help out the court by representing the individual being conserved sometimes, okay? In Alameda, it's actually the public defender's office. It's a wonderful man named John Plain. So they need to be notified. I should state, in San Francisco and San Mateo, since it's an attorney that's going to be appointed by the court, you're not responsible for notifying them. The court is responsible because you don't know who that person's going to be. But in Alameda, you would be responsible. You'd just look up the address for the public defender's office and mail it there. Okay, you have to serve a citation on the individual being conserved. That means someone actually has to walk up and serve them. You've been served, has to actually walk up and serve them paperwork. You don't have to hire a professional. You can just it can't be you that does it, but you could have a teacher or an aide or another family member or someone, a friend do it. And then they would fill out a form stating where and when they served the paperwork. And then that needs to get filed with the court, okay? It has to be someone 18 or over. And it has to be no later than 15 days before the hearing. Okay, so now let's get to good meaty stuff. The attorney, the public defender, or the attorney from the panel of the county. What is their role? Let's just be clear, no one likes attorneys. I don't like attorneys. So this makes people nervous. Oh, my kid's gonna have an attorney and this is gonna get, adversarial and then, no, don't think of it that way. That has not been my experience. And I've done a lot of these cases. Usually it's just a really nice person that has done so many of these cases and knows that you are doing your best as a parent to try to protect your kid, right? So keep that in mind. Their job is to visit the individual, their client, and speak to them. Now, let's start there. Some kids are nonverbal. Some are very verbal. So that, don't worry about that. This is what they do day in and day out. So their job, even if the individual is nonverbal or, can't process verbal information, whatever it is, their job is still just to try and engage and determine, well, how much does this person that I'm having this conversation with understand? Do they understand what this proceeding means? And if they do they have an opinion about it? Are they okay with being conserved? Are they okay with this person, say mom, being in charge of these decisions? Okay, that is what they're trying to determine. Now, again, they do it in a very friendly, non-confrontational manner, but that's their purpose. That's what their role is. And then they are supposed to come to court and express that. And now if they can't determine anything, then they'll say, I wasn't able to determine, but I have no objections based on, all the documents that I've seen and blah, 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 or whatever. Okay, in some counties, let me think, none of the county, oh yeah, in San Mateo they do. In San Mateo, the attorney will actually file, and maybe San Francisco does it sometimes, they will actually file a report that says, I met with the person and here's what happened or whatever. And then, yeah, okay. So that is what the attorney looks like in this case. Now, regional center, I said, they have to be involved. The regional center's job, let's say of that list I showed you earlier of the 7 powers you can request, let's say you have requested all 7. The regional center is going to go through each of those powers and make a recommendation for each one. That means, okay, the power to decide where they live. Yes, we recommend that this be granted to the proposed conservator. Okay, now, earlier I mentioned controlling social sexual relationships and withholding or giving consent to marriage or hot button topics. Those are specifically controversial within the regional center sometimes. They want to obviously protect the rights of their client and their civil liberties and their privacy and all of that. So sometimes they don't want to recommend that those powers be granted. I say that because I just don't want people surprised when they receive a report back. That being said, there are 2 things to say here. Number 1, if you're worried about that and you have specific things that have happened in your child's life that lead you to believe that you need those powers, you'll want to discuss it with the regional center before they prepare their report. Secondly, just because a report comes back saying certain recommendations doesn't mean that that's what the court will do. And that even the law says that these findings are not binding on the court. Okay, so I have had many, many times of a regional center report saying one thing and then, our actual case turning out a different way. So keep that in mind. I also want to just say, if you have filed all your paperwork and you have a hearing date, immediately reach out to the regional center. Let them know, because they are very overworked and very under-resourced, as you know and have experienced. And so for them to get this report done in time, give them a lot of time to do it, okay? Okay, court investigator. So this is a big part of the case. This is a person who's an employee of the court. Their job is to investigate the case and make, they basically are determining, is this person eligible for conservatorship, okay? And are you the right person to be conservator? Okay, that's really what they're determining. So the way that they do that is that they interview people. They're going to want to visit the individual, see where they live. Do they have access to what they need? Do they have clothing? Is it safe? Do they have a bed to sleep in? Do they have access to food? All that kind of stuff, right? And then they're going to interview you, and they're going to interview your child, all right? And the interview that they do with your child will be very similar to the attorney's interview, where they'll be, do they understand what this process means? Do they have an opinion about it? It's very similar. And then interviewing you, they're going to be asking you about yourself. They're going to want some background information about you, and they're going to want a lot of information about your child, from birth to current, and giving them a picture of what their development has looked like, and also your involvement in their life. They will also interview other people. Almost always, I think always, I don't think they've ever not, they will interview the regional center, your case manager, okay? And then depending on the county, depending on their caseload, depending on so many things, That will determine how many interviews, and depending on if they have any reason to be worried about your case, that will determine how many people that they bring into this interview process, okay? They might interview other family members. They might interview like staff at the school or the day program or whatever. So those are all just, you just think like, who are people involved in my child's life? And those are people that potentially could be interviewed. I have had many cases where they literally just interview the regional center and move on, okay? And you and your child, but that's it. And then they do write and they run a background check on you. One of the forms you need to complete is a screening form, a confidential screening form where you give driver's license, social security number, all that info, and they're going to run a background check on you. And then they will write a very detailed, lengthy report about their investigation of the case, and you will get a copy of it so that you know ahead of time, what they have told the court. There are court investigator fees. I said $850. I'm trying to think. All 3 counties here, it is somewhere around that number. But if you have your fee waiver that we talked about earlier, that's waived also, so you don't have to worry about that. And then we have the hearing. Okay, so all of this has led up to a hearing. What the big question: do you need to be there? Does your child need to be there? That's the big question I always get. So in all 3 counties that are here today, yes, you are required to be there. And technically your child is required to be there too. First, all hearings are still via Zoom. It's amazing. We hope it never changes. And there is no talk of it changing anytime soon. Apparently in Florida, they're changing it and people are very angry, but everywhere else, we're all happy campers. So it makes it really nice and less intimidating. You get to do it from your couch. Your child doesn't have to be scared to be in this weird courtroom. It's a way less stressful situation. That being said, it is at the end of the day up to your child's attorney if your child should attend. So a lot of kids would rather go to their day program that day or go to school, and they don't want their routine messed up and all of that. So a lot of times there are attorneys that will say, that's okay. If they've said, no, I don't want to go to the hearing, then their attorney will say, that's fine, you don't need to go. I'll tell the judge that you don't want to be here and I'll speak for you, okay? But in some counties, like San Francisco is a pretty strict county, they usually want to see the individual, okay? Okay. Oh, and there is also an area on the doctor's form, the capacity declaration, where they can state the individual is unable to attend the hearing, whether it's like, medical fragility or anxiety or whatever it is, they can make that statement. And so that can help your argument that they shouldn't be there if you don't want them there for some reason. Okay. So what happens at the hearing? Not a lot. If you've done everything that you should do, all your paperwork has been done correctly, nothing weird has come up in any of the investigations, everyone's interviewed you guys and your child, and everyone's on the same page, then the hearing is just a formality, but you have to show up, and the judge wants to see your face on the Zoom camera, and then they basically sign your order and send you on your way. One thing to note about hearings, you are not the only hearing. If you have a 9 a.m. hearing, there are probably anywhere from 1 to 15 other cases on the calendar that day. So keep that in mind. You might be there for a while, because people always ask me, how much time do I need to set aside? And I cannot really answer. So just know that it's not just you, it's lots of cases being heard. And sometimes the judge may ask a question or two. It's usually nothing scary. And then the judge will sign your order and send you on your way. This is the document, letters of conservatorship, that is what you need at the end. This is the document you show to the regional center, to your school, to the day program, to the doctor, to whoever it is. So what you want to get is a certified copy of this at the end. They put a very special type of stamp on it, and you pay for that certification stamp. But if you have a fee waiver, you don't have to pay. I think San Mateo has a rule like you get 1 certified copy or something. Some other places you can basically, I think, just get as many as you want. Okay. So it's important to know, because there's 2 documents. There's the order That's what the judge signs. And then there's letters of conservatorship, which is what you need to get to show. That's what you're going to show people. All right, after the hearing, what happens? Ooh, I'm good on time. Okay. I'm going to take a breather. Whew. We're almost done. I know some of you guys have probably been here all day. Okay, documents that must be filed after the hearing. I'm not going to go into great detail, but there is more paperwork. And the notice of rights, that's just something you have to mail to the same family members we mentioned earlier. They all get a copy saying this person's now been conserved, but they still retain certain rights. Okay. And they still retain the right to like open their mail and have people visit them. And, you know, there's certain rights by law that they retain. A determination of care is a very simple document. You just state how many hours of help they need with certain things and where they live and that kind of thing. And then most counties, all 3 counties here, have a general plan. And that's a more detailed document. Each court has their own. So you're not going to find that on, you know, the main Judicial Council website. You'll find that on each court's website. And that's a much more detailed, you know, breakdown of their needs that you have to fill out. And those all have to be filed within I always just, as soon as the case is over, I get them all done and file them and and then move on. Something that I actually just remembered is not on here. San Mateo County and San Francisco County, not Alameda, require a course. There's a course you're required to take. I'm totally blanking right now. I know San Mateo has it. I'm almost positive San Francisco has it too. It's a course you have to take. They do it online via Zoom. And the information is all available on their website, but that's just within 6 months you have to have taken it. Okay, conservatorship maintenance. So the conservatorship, a limited conservatorship, lasts for as long as you are alive. Once you're not alive, technically that conservatorship is supposed to end because there's no one to manage the care anymore. All right. So how do you prepare so that that doesn't happen? Well, a couple of things. Oh, you know what? That's my next slide. I'm not even going to go there yet. Hang on. So that's one way that it terminates, is you die. The other way it terminates is if the court says it's not necessary anymore. So the court comes and does check-ins. So they're going to check on you, check on the individual who's conserved after the first year and every 2 years thereafter. Okay, let me just say, that's what they're supposed to do. Courts are under-resourced, and so that doesn't always happen, but that's the idea behind it. That being said, some courts, including San Mateo and including Alameda, have a form that you fill out once a year that you just have to submit to them. It's just it's kind of like the general form. It just outlines some of the stuff that they need help with and all that. Yeah, if they move, this is the one I get a lot. So if they move within the county, no big deal, but you do need to notify the court. You're required by law to notify the court that you're supposed to notify the court before they move and after they move. Most people don't do it until after they move. If they move out of county, then you would move the case to that county, and each court has their own process for doing that. If they move out of state, now you are in a whole new world and need to actually start this process in that state. It's not transferable, okay? And technically, you're supposed to get permission from the court to move the individual out of state. Okay. How do you prepare for down the road? This slide, the first couple things we talk about are about conservatorship, and then the next two are not. So let's start. Okay. How do you prepare for down the road for your conservatorship? You're not going to be able to be conservator forever. So what do? Well, you have two options. Number one, you have a document that you've nominated whoever you want to take over for you. That would be, you could do it in your will. If you're doing your estate planning with an attorney, you could ask them and say, please put this as part of my will. Or you could just have your own separate document that says, if something happens to me, here's who I nominate as conservator, and I would list at least 3 people in order of preference, okay? Now, let's say you've done that. You have it written somewhere. And you walk outside and something happens and you can no longer be conservator the next day. That doesn't mean that person now becomes conservator because you wrote it on a piece of paper. That just means that person goes to court and gets appointed conservator in a similar process to what we just went through. And they have a proof that you intended them to take over, that they can show to the court, okay? But it doesn't make them conservator just because you've written it on a piece of paper. That's really important for people to understand. Second of all, second option, you appoint someone to be co-conservator with you, okay? I just helped a 94-year-old woman appoint someone to be co-conservator with her because she realized, hey, I'm not going to be able to do this forever, right? So that's another option, is down the road sometime you appoint someone to be co-conservator. And then you know, once that you can't do it anymore, there's already someone who is a conservator and in the role. Okay, those are the options of how to set yourself up for success for the future. All right, now these other two areas, these do not have to do with conservatorship. Like, take off the conservatorship hat now, and like, this is completely unrelated. I just like to give you guys this so that you can have this on your radar for thinking forward. Number one, if you're going to leave your child any money when you die, there are two issues. Number one is, can that child manage the money that you're going to give them? They suddenly have a bank account with $10,000, $100,000, whatever it is. Can they manage? Can they do anything with that? Do they know what to do with it? Okay, if they don't, then you're going to want to put some sort of system in place for somebody to manage it for them. Second issue with it, what if they receive SSI? SSI has a $2,000 threshold. If you have more than $2,000, you're not eligible for SSI. So suddenly, you have $10,000 in a bank account, you're ineligible? That's not ideal. So a special needs trust is something that you can set up ahead of time, and you say, any money going to, Joe, my son Joe, is, instead of going to Joe, goes to his special needs trust. And I'm putting so-and-so in charge of that special needs trust. So now you have two problems solved. Number one, the money in a special needs trust doesn't disqualify Joe for public benefits. And number two, whoever you put in charge of the special needs trust will be managing the money and making payments for what Joe needs, and Joe doesn't have to be involved. Okay, that's number one, special needs trust. Highly recommend. Number two, ABLE accounts. I used to show up at these things and I'd say, has anyone heard of an ABLE account? And no one had. I'm going to do it right now. Has anyone heard of an ABLE account? Oh, a few people. See, it's getting better. So Obama signed this into legislation. That's how long ago this was. And then California got theirs up and running, I don't know, 2 years ago. I have no concept of time anymore. And it is a tax sheltered savings account specifically for individuals with disabilities. It is a 529. For those of you that know what a 529 college plan is, same concept, but it's, instead of a 529C for college, it's a 529A for ABLE. 529A account, it's a tax sheltered savings account. An individual can contribute, any individual can contribute to this account up to a certain amount a year, and that person stays eligible for SSI up to $100,000 in savings. Pretty cool. So, highly recommend you look into it. I've given you some resources right here. This ABLE 10 Things to Know is a really great 10-minute video that kind of breaks down what an ABLE account is for you. CalABLE is California's program. You can Google it. Okay. That's me. I said all these slides, I have a handout I can send to you. You would just email that email address and I will respond on Monday and send you the handouts. I have my own law office. This is what I do all the time. And I also have something called DIY Limited Conservatorship. It's an online program that teaches you how to do this program yourself. I mean, how to do the conservatorship yourself. It goes through every single form. I literally fill out every form with you on there. It's like a whole thing. So it's cool. I used to show up to these all the time, and people were like, I can't afford an attorney. I have to do this. I'm so stressed out. So I said, all right. So I set up a program where you don't have to pay for an attorney. You just have to pay a smaller amount, and then it'll teach you how to do it. So now, questions. I know you guys are probably really tired. Yes.
Okay, what's the average fee for an attorney?
Average fee, such a good question. I would say it ranges from Okay, well, it probably ranges from pretty low. I'm just going to be honest, I don't trust attorneys that do it for very low. It'll go all the way up to like big firm $10,000 type money. I would say the average probably falls between 4 and 7.
And second question, to file for a fee waiver,
Yeah.
do you have to do it electronically or do you literally physically need to?
Oh, that's a really good question. So everyone who's representing themselves and doesn't have their own attorney can actually go into a courthouse and file documents. You don't have to do e-filing, which is a new thing that attorneys usually have to do. So you can go and actually hand it to the filing clerk in a courthouse. Is that okay? Your first question about fees, I also want to say, it's good to know attorneys have 2 different ways of doing things. Some attorneys charge you by the minute. Literally. It sucks. And they overcharge you by the minute, I will say. So that is one thing so there's 2 options when you talk to attorneys about their fees. Number 1 is, are they charging me by the minute? And if they are, can they give me an estimate then of how much this is going to cost? And usually, honestly, these types of cases are usually pretty, like, they know exactly how much time and work it's going to be. So they should be able to give you a very good estimate of time, of amount. Or they do flat fees, and then you know exactly what you're paying. Okay, so just know that when you're going into conversations with attorneys, if you are. Okay?
One last question.
Yeah.
Sorry. So when you talk about the fee waiver, so let's say somebody qualifies for Medi-Cal.
Yes.
And in-home support services.
Yes.
But they don't get SSI.
That's
So
fine.
they still qualify.
Yes, as long as any box is checked. A box needs to be checked. Yep.
Thank you.
Okay. Yes.
Talk more how to decide about conservatorship estate versus trust versus able to.
Oh yeah. Don't do a conservatorship of the estate. Nightmare. It is okay. Let's say you die and you've left your child money and you haven't set up a special needs trust. Here's what happens. That suddenly this child has X amount of money or whatever it is. Who's going to manage? Like, it's a mess. Like, who's going to manage that for them? Can they manage it themselves? Now they've lost their SSI benefits. Now, like it just, everything blows up. What ends up usually happening is someone who's in charge of figuring all this out goes to an attorney and says, help. And the attorney says, we're going to court. We're putting it in a special needs trust. So they're going to do it eventually, one way or another. You're going to save a ton of money for the person who needs the money by doing it yourself. Here's why. Going to court and setting up a special needs trust after you're dead is not cheap. It's also a long process, and once it's done, the court gets to supervise that trust, and you have to do accountings to the court after the first year and every 2 years, showing exactly how every dollar has been spent. And the court goes through that accounting with a fine-tooth comb in some counties and then says, okay, that's okay. And that costs money because you have to pay someone like me to do it. So if you want to save the most money for the individual who's going to benefit from your inheritance, set up the special needs trust in advance. It is just part of your regular estate planning plan. It is like a little extra additional whatever fee they charge you, and that is way less than what someone's going to pay later down the road that's going to come out of your child's money to fix the mess. Does that help? Able accounts can only receive up to whatever the current year's gift tax amount is. Is it still 16,000? I think. God, I'm totally brain dead today. 16,000, let's say. Might have gone up to anyway. That's all it can receive. So if you die and you leave your child $20,000, that all can't go into the able account. So that doesn't solve your problem. Okay? Does that answer your question?
So why are estates so bad?
Because you have to account to the court. Oh, even if you don't do the special needs trust and you just have a conservatorship of the estate. Sorry, I didn't make that clear. Good question. If you decide, I'm not going to do a special needs trust, I don't want my child to have public benefits, I'm just going to put the money can just be in a conservatorship of the estate, you still have to do those accountings after the first year and every 2 years after to the court showing exactly how all the money's used, and that costs money. And they get to see what's happening with, if you want no court oversight and no court telling you what you can and can't do with the money, then you don't want it in the conservatorship. Okay? Yes? Oh, I get those calls all the time. The California law is set up in such a way that unless the individual basically has nowhere to go, like no options, that's when they'll come in with an LPS. So if you have a child who can come back to your home and that you are trying to help support, that makes them technically ineligible for LPS conservatorship. It's kind of a mess. So it's basically people on the street who have severe mental health issues that are eligible. All that being said, I don't do LPS conservatorship because generally speaking, in my experience, it's incredibly difficult to get one because it has to be the public guardian and not a private individual that initiates it. And then so the real only way is when they're in a 5150 hold in a psychiatric unit, you would need to push and push and push to get the attention of the public guardian to get things going. But there are attorneys that specialize in this specifically that could probably give you better help and guidance, okay? But it's a somewhat broken system in California.
What does LPS stand for?
Lanterman Petrus short. It's like it's initials for 3 names. Yeah. Yes.
Who's the best person to set up the special needs trust? Attorney that's setting up your estate?
Your estate planning. Yeah, you want an estate planning attorney, though, that specializes in special needs trusts. There are so many good ones around in the area, and I'm happy to recommend people. I used to do special needs trusts, but conservatorship took over, so I don't do them anymore. But I have amazing colleagues, so I can if you want to send me an email, I can recommend people. But yeah, if you just even look at their website, like go to someone's website, if they don't have anything on their website that says anything about special needs planning and special needs trusts, I wouldn't use them. Because if it's not drafted exactly correctly, it won't follow the guidelines it needs to follow. Okay? Yes?
Can you elaborate a little bit about what you were saying about the program that you have created for a smaller fee?
Yeah.
So is that like a template and we follow the template?
No, that's a good question. So it's videos that you watch, and it's like, it's me giving you help and information and whatever. And then I like the video goes through each form, and check, and here's how to fill this line out, and here's what this should say, and blah, 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 blah. An online course.
And then to get that, we'll contact you, and then
You can just Google DIY limited conservatorship, it probably comes up. But yeah, you can also email me. Yeah. Yes.
Does being a conservator open up the conservator to any
Liability.
Like you know, if the conservatee
Like punches someone in the face.
property
Yeah.
damage,
It's a good question. So this is a hard one to answer. So under conservatorship law, no. So conservatorship, you becoming a conservator, your responsibilities have to do with making sure that person has their needs are met. That's your responsibility. Your responsibility is not, okay, like he walked down the street, he was very angry and he punched someone in the face, and now that's my fault because I'm their conservator. So that's not under conservatorship law. Conservatorship law doesn't state that. But that being said, if outside of conservatorship law and just regular, the way the world works, if you know that they're a risk or they're a danger or there's some situation and you have not helped prevent it, someone can make an argument against you, right? So, but not within the conservatorship realm. I mean, they might say use conservatorship as a argument of saying you knew this, whatever, but not really. Yes.
So if we're afraid of a situation like you mentioned about someone
Yeah.
to a bank and opening an account,
Yeah. Oh.
wouldn't we need a conservatorship?
So yeah, so some people do conservatorship to the estate, even though there's no estate, and then you can freeze their credit.
We would need an estate for that.
Yeah. Yeah, I'm sorry. So when I said you should avoid a conservatorship of the estate, I meant you should avoid a conservatorship of the estate that has money in it. But just having an empty conservatorship of the estate because you are worried about someone doing something like that, that's fine. Yeah. Okay, other questions? Oh, man. All right. Thank you. I'm so glad. Okay. Oh, love it. Don't forget to fill out your forms. They need those. It is important for funding. I sit on the board of a sister organization to support for families. They do need those. Be honest, I won't see them. And also consider a donation if it's within your ability. All services they're providing are free, and it is rough in this federal government funding world. So And I'll stand around for a couple minutes in case anyone has any last minute things that they didn't get to ask. Yeah.
Yeah, I have one question.
Okay.
About, there's a document called GC0A0FA.
Okay.
Yes.
See you.
Yeah, my question is this is attached to both more notice of change or residence? But the conservator, they need to fill out their
When the person moves?
they need, my question is, they need to fill out maybe their friends or maybe their family.
Oh, yeah.
Name and the address. And one of my family, now they have trouble is they fill up that, and then one of their extended family members, agree to put their name on that. Because they worry they will get trouble after they die, they may take over the conservatorship, even though they explain that to that no, that's not true.
Yeah.
But they still want to take off their land. So I'm wondering how about the process?
So the only people that are required to be listed are parents, siblings, and grandparents, right? And is it one of those people? Okay, well, that's not their choice. So it's law that you have to name those people and they have to be mailed something. That's literally where it ends. That person has they're not involved in any way. But I don't know what else to say. It's not up to that person. It's the law requires, and the court will require that they list their address. The idea is to it's just they're just going to receive mailed notice that the hearing is taking place. That's it. They don't have to do anything. They don't have to do anything. There's no responsibility associated with being listed on there. Yeah.
Yeah, that's what the
Yeah.
conservative
Yeah. Yeah.
They still want to take off their name, so I wonder.
They can't. No, I mean it's not doing anything to the sibling. Yeah. I mean, otherwise the person's going to have to file a document explaining why they can't put the address of their sibling, and the court will probably say, "This is silly. You know where they live. You need to do this." Yeah. I know it's so ridiculous, but yeah. Yeah. Yes. Yeah. Yes. Yes.
So when I do conservatory, do I do it here and in Michigan? I mean,
Well, this is his permanent place of residence.
this is a permanent place of residence, but
You can just you would just do it here.
okay.
Yeah. Okay. Yes.
Especially some get income from the S corporation.
Oh, okay.
Less than 12,500, whatever that is.
Yeah.
But he does not file income tax return.
Yes.
So how do I shelter them so that he will later get his social security?
Oh, you can put that into an ABLE account. Yes.
What is the limit? Did you say that?
It was 16,000 last year. It might have been raised this year. I'm embarrassed that I don't know. I could Google it. But anyway, whatever the gift tax exemption is any given year.
So every year you can
Yes, exactly. Yeah. So right now you fall under it. Yep. Okay.
Great.
Yeah.
Thank you.
Yes. Yes. Yes.
So does that count? I mean, because the way we see it, the only way we're going to do any kind of conservatorship is if consent somehow to it.
Right.
But she isn't going to
Not-
consent to do anything.
Sure. I'm going to suggest you're welcome. Suggest an attorney's name. Greg with double E. It's actually a woman. Bryon, Bryon. And if you email me, I have her email address. Bryon. I think that's right. Yeah. And that person's going to have more expertise than I am. San Francisco. Okay. Yes.
No, my son is 17.
Okay.
So I'm looking for.
Yeah, you're thinking about this?
conservatorship.
Yeah.
So you do the conservatorship?
Yes, yes.
You do. Okay. So
Yeah.
I can contact you.
Yeah, definitely email me. Okay.
So what is your fee?
So I charge a flat fee of $6,000.
Okay.
Yeah. Are you in San Francisco?
Yeah.
I have a really amazing colleague that I love in San Francisco, and I might send you to her just because I don't love handling the San Francisco court, and
Oh, is
she's
it
like there all
harder?
the time. Oh yeah, they're awful.
Oh my God.
They're not awful for you. They're just
Oh.
awful for attorneys. They make it. They're just like so nitpicky. It's like so annoying. So, but email me because whether it's me or my friend Melanie, she's amazing. So one of us will
Melanie?
help you. Yeah. Okay.
Oh, so you're in Marine?
Yes.
I work in Marine. I work
Oh.
in Summerfeld.
Oh, right on. Okay.
Yeah. So Melanie.
Yeah.
What's the last name?
Emmons. EMMONS. MONNS. N.
Oh,
NS. There you go. You got
Oh,
it.
there you
It did
go.
it itself.
okay.
Yeah, she's great. She's at a firm here in San Francisco.
Oh,
She's
okay.
super nice.
And
Yeah,
same-
yeah.
same.
Oh yeah. Oh, I don't know. I think
You
they
don't
do.
know?
I think they do billable hours. So
Okay.
I don't know, but she'd probably give you an estimate. She knows probably how much it ends
Okay.
up costing.
And how about for special needs trust?
That firm does them too, and I don't know what they charge for that. I'm not doing special needs trust anymore.
Oh, you're not?
Yeah.
Okay. And what is her friend is her name?
No, she's with another firm, but if you Google her, you'll find her. But you can email me. You can.
Okay.
Yeah. Okay.
Thank you. That was
Yeah.
a great presentation.
Okay. Oh, good. I'm glad. Okay. Yeah. Go. Feel free. Hi.
Like state probate done with the special needs fund on the at the end of it. So can we get a reviewed actually over time? The attorney.
Oh, your estate planning. You've already done it. Got it.
Yes, and then the special needs trust is supposed to be attached to it. But
Yes.
Probably the attorney retired, and so should I?
Ah.
Probably because I think it's irrevocable. Irrevocable.
Yeah.
So we
Yeah.
could probably look at it.
Yeah. How long
periodically.
ago was it done?
About maybe 5 years ago.
Oh, it's probably good for a while.
Yeah.
But yeah, I usually attorneys tell you that you should check in once every X amount of years. Like every firm has like a different
They give
amount.
us a big binder.
Yeah.
And the other thing is that representative payee, because I'm a representative payee of my son.
Yeah.
But the one thing, he's working right now, so he doesn't get Social Security anymore because he makes much money. But
Yeah.
but it's kind of a catch-22.
Yeah.
So I think the thing is that, but I don't think he can still manage his money, so I continue to be able to do that.
Yeah.
It's
I
kinda
mean,
difficult.
technically, conservatorship of the estate wages are supposed to fall outside of that. It's so silly. So technically, that's not even supposed to be something that you would manage through a conservatorship. All that being said,
I mean, a lot of times when you get government papers, you get like it's sent to him and to me. Usually,
Yeah.
me opening it.
Yes. yeah. So it sounds like it's working for you so far.
So far, but
Okay.
I was wondering, like later on, can we add somebody else, like to the representative payee? Because usually,
Oh,
it's
yeah.
one person.
Yeah, so there's something called an
Like a manager?
authorized representative, which is for like Medi-Cal, for Social Security, that you can have be. It's not.